Good morning to all of you. Welcome to Legal Matters by Sai Babu Sokara. CPC students, Law of Injunctions. We are discussing only temporary injunctions. Basically, even though the word injunction is not defined anywhere in the CPC, you can understand that injunction is a court order restraining a party to do something or encouraging a party in doing something while the case is going on, as stated in the case of the Gujarat Bottling Co. Limited versus the Coca-Cola Company 1995. So you can understand that injunction is a judicial process whereby a party is required to do. A party is requested to refrain from doing any act. It is a temporary remedy. It is a remedy in the form of an order of the court addressed to a person, right? Either prohibiting him to do from doing some act, right? Injunction is a relief that prevents or restricts from doing any act, right? So when you refer to section 94, right? When you refer to section 94, subsection C of the Code of Civil Procedure, in the supplementary proceedings, it is clearly stated that the court can give temporary injunction order based on section 94C. Of course, 95 you also know. If the injunction is granted on a false claim, then compensation may be given to him. Right? So, basing on these sections, there is an order number 39, which is containing rule 1 to rule 10. Of course, rule 1 to 5, they relate to injunctions, and rule 6 to 10, they relating to orders, that is interlocutory orders, IS, that is like stay, status quo ante, like that. Now, the injunctions are, please remember, for actually three purposes, three types of injunctions. Number 1, preventive. Number 2, prohibitive. Number 3, restrictive to something. Right? So, sometimes they are called, temporary injunctions are, we call them as ad interim injunction. That means till the case is going on, till the case is disposed of, or per a particular time. Even adherent also, it will be mandatory injunction. What is mandatory injunction? Direction, compelling to do, that is mandatory. Order to do, mandatory injunction. You may be knowing, for implementation of the mandatory injunction, you can file EP within 3 years. That is the deadline. Normally EP వేయడానికి 12 years అనుకుంటాం. Mandatory injunction అయితే 3 years మాత్రమే. Right? Then who can apply? Basically, whether any suit is necessary for obtaining an injunction order. Please remember, this is an order. While discussing judgment, decree, order, you have to remember injunction is an order. Right? So, this can be obtained even without instituting a civil suit. That's the base law. Then who can get the injunction order? Both parties can go. That is, the plaintiff while the case is going on. Defendant, if he has got balance of convenience on his part, yes, he can also apply for the so-called injunction. Please remember, judicial officers, you cannot go for injunction against the judicial orders, officers. Please remember. Then ex parte injunction, it is appealable. While dealing with order 41 also, I told you, section 92 నుంచి చెప్పాను, right? And ad interim mandatory. Then there are other type of injunction, that is permanent injunction or perpetual injunction. A mandatory injunction can become a perpetual injunction at the time of judgment. Right? Permanent injunction, even I need not explain what is a permanent. It restrains a party forever from doing any specified act. Right? So normally for permanent injunctions, we file the suit under section 26 of the CPC, particularly injunction, section 38 to 42 of the Specific Relief Act 1963. right? So please remember, it cannot be issued against the judicial officer. Just now I told you. Then, in which circumstances court can give the so-called injunction order? 3 points you should not forget. Number 1, there should be a prima facie case. Prima facie case in the favor of the petitioner, whether he may be a plaintiff or whether he may be a defendant. Second, balance of convenience. This is very, very important. Balance of convenience is in the favor of the petitioner and against maybe the defendant or plaintiff. Third one, if injunction is not given, irreparable loss, irreparable injury is likely to be caused to the petitioner and which cannot be compensated in terms of money. If these 3 conditions are there, definitely the court can give injunction. Normally, for injunctions, the court has Rule 3 చెప్తుంది మీకు the injunctions notice to be given to the other opposite party, but in the circumstances which are going out of control, they can definitely give injunction even without giving notice to the other party. Whatever it is, the injunction petition should be decided within 30 days. I think it is the 30 days period. Right. Normally, where injunction can be granted, the conditions, number 1, maintain status quo. Actually, మనం IAలో చెప్పాలి ఇది. Against transfer of property, disposal of goods, sale. Rule 4లో చెప్తాం కదా. Then making construction at the time of construction. ఎందుకంటే when the ఫస్ట్లోనే చెప్పాలి మీకు ఇది. When the defendant is trying to dispossess you, ఎప్పుడన్నా మిమ్మల్ని ఇక్కడ నుంచి తీసి అవతల పడేస్తానంటే, when he is likely to cause damage to the property, damage or alienation of the property, when he threatens to when he threatens to remove you, when he threatens you to dispossess from the property, definitely injunction order can be given. Normally construction appudu vastayi. Then affecting recovery of the dues. Then attachment of property, yes, definitely injunction orders can be given. Appointment receiver, sale లో receiver కూడా వస్తుంది. సో కాబట్టి అగెనెస్ట్ ప్రాసిక్యూషన్ సిఆర్పిసి వచ్చినప్పుడు 482 సిఆర్పిసిలో మనం స్టే ఆర్డర్ ఇస్తే అది క్వాష్మెంట్కి వెళ్తే స్టే ఆర్డర్ ఇస్తారు. రూల్ నెంబర్ 6 నుంచి దాని గురించి వస్తూ ఉంటుంది. సో కాబట్టి ప్లీజ్ రిమెంబర్, టెంపరరీ ఇంజంక్షన్ ఈజ్ డెఫినెట్లీ very, very useful. Rule 3 deals with the ex parte injunction. That means even though notice is given, when the parties did not present, ex parte injunction can be given and it is appealable order. Please remember, normally on injunctions we go for revision, but ex parte injunction matram appeal ki vellavachunu. So this is the simple law relating to the law of injunctions. I hope you understood. Thank you very much.